Hello everyone, this is John Milburn, Central Queensland University, Week 3 in relation to LAWS19038, Planning and Environment Law. This is based on England, Chapter 5, and is about urban planning policies and instruments, with particular emphasis on the Integrated Development Assessment System, or IDAS as it's known. Before we start, I'd ask you to take your book, commentaries and go to page 131, and I'll start making comments from there. However, by way of introductory comment, can I say in relation to the interplay of legislation and case law that it's not an easy concept to grasp, particularly for non-lawyers, but generally speaking, what we would do is firstly consider any legislation and bear in mind that any Commonwealth legislation will override. Sorry, David, I might just get you to put your microphone on mute if you don't.
Sorry.
You're right.
How do I?
Just down on the bottom left-hand side, there should be a little microphone.
Oh, okay.
If you click that icon, it will go on to mute. So, sorry for the interruption. So where we have Commonwealth and State Law, Section 109 of the Constitution provides quite simply that where there's an overlap, where there's an inconsistency, we should look to the Commonwealth law as prevailing. In a sense, the same applies where we have statutory law and common law. If a statute is passed after a case is decided, then the statute will overrule the effect of the case law, which means overrule the effect of the common law. Common law is simply judge-made law. There's nothing more, no more magic to it than that. So if, for example, in the Mabo decision, which is an instance of case law or common law, the Commonwealth government introduces new legislation, it will then override the case. That was done with the introduction of the Native Title Act the year after Mabo was decided. So what was originally common law or case law, and that is the concept of native title, then became statutory law with the introduction of the Native Title Act, which I suppose supplemented and then where inconsistent overruled Mabo. That's misleading language because it didn't overrule it at all. It basically adopted that principle in a statutory form. But the point is that where you have material that's coming to you, which is some of it's statutory, some of it's case law, some of it's common law, some of it's state, think in terms of looking at the statutes first and then the case law would be the general rule. And as we discussed last week, in planning and environment law, because it's so new, most of it is statutory based, although we're seeing more cases coming through which generally interpret the legislation in relation to a particular section or a particular concept. All right, now let's go back to page 183 of England and introduction to IDAS. So that's the Integrated Development Assessment System. England makes I think an entirely appropriate comment at page 183 where she says the Integrated Development Assessment System is Queensland's system for managing development assessment. It provides for an integrated procedural framework through which all aspects of development application are assessed by local governments and state agencies if required. The aim is to create a one-stop shop for development applications who will benefit from integrated and streamlined development assessment procedures. When IDAS was first introduced in 1997, it was described by the appropriate minister as the greatest assault on development red tape ever to be undertaken by any jurisdiction in Australia. That's a big call that was made, but it is clear that the former system was largely ineffective and it was inconsistent in its outcome. IDAS identified the procedures and importantly provided the timeframes within which applicants, local governments and referral agencies must perform their various duties. I'll move on to page 136. And could I just say my logic in following the book so closely is twofold. The first is, because in my view this is such a massive subject in terms of the reading material which is prescribed, it's appropriate that I try not to distract you with extraneous material too much. So I really want you to know the book and understand the book. And by taking you through the book, I'm really identifying what I believe is the main points by way of summary, and I'll provide additional comments as we go. As you would have seen in Moodle, my suggestion is that you at least read the summary before we go through, follow it as I'm going through the material, and then reread it and make your own notes. And then hopefully by the third reading, it's all starting to make some sense. I'd encourage you also to make comments on Moodle, interact with each other, and provide various commentaries by way of your comments in Moodle. So thank you. Now 136, England says, IDAS is the procedural framework for assessing development applications in Queensland. It is premised on two key concepts, development and assessable development. So it makes a distinction between development per se and assessable development. She then goes on to say that where there is a change in the land, the use of the land, the Sustainable Planning Act will become relevant. Now, development, you'll see there's a list on page 136 through 137 where it's expanded, and that means that development is carrying out building work, carrying out plumbing or drainage work, carrying out operational work, reconfiguring a lot, making a material change of use of premises, and that's section 7 of the Act. So when we talk in terms of development, we don't mean just a subdivision, we don't mean just the construction of a building, we mean all sorts of works that might have an effect on property. So that's building work, plumbing work, drainage work, operational work, moving land around, building canals or dams, etc., would be operational work. Reconfiguring a lot, changing the lot's size, dimension, etc., and then making a change of use of the premises. But not just any change, it has to be a material change to qualify as development work. Now, at page 137, England goes on to say, the definition of development in the Sustainable Planning Act is broad. Whether or not the use amounts to development is generally not a matter with any particular ramifications under the Sustainable Planning Act. It is not the trigger for assessment under IDAS. So development itself is not the trigger. The critical question in Queensland is whether or not any particular development is self-assessable, compliance assessable, assessable, or prohibited as prescribed under the Act. That's the Sustainable Planning Act. If the development falls into none of those categories, it is exempt development, and that's over on page, the start of 138. So what it means then is this. There is a two-step process to be considered before we conclude that IDAS is relevant to a particular development. First, we need to determine whether the action in question is appropriately defined as a development, and that would generally be pretty easy because there's a lot which is covered by development. But if so, the second question is, what is the nature of the development? Is it self-assessable, compliance assessable, assessable, prohibited, or by default exempt? And if it's exempt, then the development simply must comply with state planning regulations, and that's section 235, subsection 2 of the Act. So what development then is assessable? And if so, how is it assessable? So what I'm really talking now about is the second limb as I've described it, and that is where we have to make the decision that a development is one category or another. So let's go forward to page 140 in England under the heading of what development is assessable, and I'd add a subheading which is, if so, how is it assessable? So the Act, as we've identified, recognises 5 categories of development: exempt, self-assessable, compliance assessment requirement, assessable development, and prohibited. The first one, exempt, is the default position. The second, self-assessable development, is development that does not require a development permit but must comply with applicable codes, which is really at a lower level. That's section 236. So that's self-assessable development. That's the first type. Going up from that, the next rung up the ladder is such development which requires compliance assessment, and we refer to section 237 of the Act. In that instance, it simply requires a compliance permit. The third level up is assessable development, and here we break into 2 categories. Assessable development is categorised as either code assessable development or impact assessable development, or perhaps both. And the final 2 are assessable development. I'm sorry, that was assessable development, my apologies. And the final one is prohibited development, which is where it's an offence to carry out the proposed development, section 581. So why is it important to consider the different types of development? Firstly, exempt development and prohibited development, which are at the opposite ends of that 5 category spectrum that we discussed, are dealt with in 3 different ways. Are dealt with in different ways to the other 3. So let's have a look at how that's described. If we go to page 142 in England, we can see that the statement is that dividing development into broad categories, those 5 different categories, allows for different types of development to be assessed more or less thoroughly. The assessment regime is risk-based and conducive to performance-based assessment. So the idea, I guess, in theory is that by categorising various developments in a different way, we are changing the rules in relation to those particular developments. It's not a case of one system or one set of rules caters for all. The higher the risk, the more significant, the more intrusive, if you like, the development assessment regime. Looking at pages 142 now through to 158, that block, that's under the heading of IDAS timeframes and procedures. Now, possibly a little dry, this bit, because we're really talking about mechanisms to ensure that the applications are dealt with appropriately in a certain manner. But let's go through it. Starting at 142, England identifies that IDAS involves up to 5 stages. That is the application stage, information and referral stage, notification stage, decision stage, and compliance stage. And as one might glean from those headings, those orders are effectively chronological, or those headings are chronological. So number 1, the application stage, which is at 142 in England. In the application stage, an assessment manager, and an assessment manager is really a person who's nominated by, typically at the council, in relation to these applications. So in the application stage, the assessment manager determines whether a development application, firstly, has been properly made. If it hasn't been properly made, that's the end of it. But if it has been properly made, then the assessment manager will determine what type of assessment is necessary for that application. And England provides a brief summary at pages 143 and 144 of the main features and requirements of the application stage. For example, stage 5 of the application stage requires the assessment manager to give the applicant an acknowledgement notice within 10 business days of receiving a properly made application. All right, so a bit of nuts and bolts there. I suspect that that's all a bit dry in isolation of actually dealing with real life cases where it becomes more interesting. But anyway, it's there if you need to have recourse to the stages, and England has identified 9 stages within that first stage being the application stage. Let's move on to the second stage of IDAS, timeframes and procedures. The second stage is the information and referral stage, and referral agencies may be concurrence or advice referral agencies. So a referral agency is really an outside agency that has some interest, some specialist knowledge, ability to deal with the application that's made in that particular instance. So refer to section 252 of the Act in that regard. England provides a brief summary of the main features and requirements of the information and referral stage at pages 145 right through to page 148. Again, I won't go through that in detail. That's there ready for you to read if you need to know the procedures, and she identifies 11 procedures which are relevant to the information and referral stage. A concurrence agency, as we indicated, is an outside agency that may have some responsibility, authority, requirement to deal with issues, and the referral could be for concurrence, meaning effectively an agreement, or it could be simply a referral for advice, and that's section 252. All right, now the third stage in IDAS, we're still talking about the IDAS timeframes and procedures, is the notification stage. And this is dealt with in England at pages 148 through to 150. The notification stage is really the opportunity for people, the public, to be made available of the to access the development details and make submissions about any application. And the timeframes and the rules are set out in points 1 to 5 on 149 and 150. I'll leave you to read the detail there if as you see fit, but it's really made clear that the notification period starts at a certain time, and there's notice on an applicant to give public notice, and people are entitled to make submissions in relation to that application. I heard in the news today that there are moves to remove what appears to be that stage of IDAS in relation to certain mining regimes and licensing requirements. Now, if I could move on to the fourth stage, which is the decision stage, and that's where the assessment manager brings it all together, makes a decision, and England provides once again a brief summary of the main requirements and features of the decision stage at pages 150 through to 153. Once again, we have a number of 155, a number of different issues that need to be considered. It is broken up, however, into 2 stages. That's the assessment generally, which is through 3 through to 10, and then the notice of the decision, which is 11 through to 12, and then so on through negotiated decision notices and approvals. If any part of the application requires what we call code assessment, the assessment manager must assess the application against various instruments. the state planning regulatory provisions. Now, you recall that's at the very top of the tree in terms of being legally binding. Below that, we have the regional plans, applicable codes, state planning policies, and applicable codes in local planning instruments. When we talk about instruments, we're really just giving a name to something which has some legal effect. Arguably, a transfer of land is an instrument, or a deed or a contract might be regarded as an instrument. So when we talk about instrument, we're really just giving a name to these various pieces of statutory authority, such as the state planning regulatory provisions, so that it's a way of describing them, that's all. Now, if any part of the application requires impact assessment, the assessment manager must assess the application against following instruments, and they're referred to in England as well: the state planning regulatory provisions, regional plan, state planning policies, any applicable structure plan, and the planning scheme. Now, the fifth stage, which is on page 155 and 156, is the compliance stage, which enables development documents or work related to the development to be assessed. The compliance against other applicable regulation and planning instruments is required to be undertaken pursuant to Section 393. And once again, there's a brief summary of the main features and requirements of the compliance stage on pages 155 to 156. All right, now I apologise, I find that a bit dry. Some people might really like that type of compliance issue, but I guess the main point is to know it's there, and to follow those guidelines. All right, let's talk about, from my perspective anyway, from a legal perspective, some more interesting facts. And becomes more interesting at page 159 when we talk about things like what happens if a procedural requirement in IDAS is not complied with. England makes the point that IDAS is essentially a procedural framework for managing development applications, which is true. IDAS spells out rigid timeframes and other procedural requirements designed to ensure quick yet comprehensible assessment. But there will be mistakes made, or there will be errors made, or there'll be issues arising rather. For example, if there's a factual error, an acknowledgement notice might fail to identify a referral agency for concurrence or advice, or the applicants may fail to provide specified information. A referral agency might wish to respond but leave it too late. There might be a requirement for public notification that may not have been complied with, or the assessment manager may have failed to make a decision within the statutory timeframes. So the Sustainable Planning Act includes some general provisions for managing these issues. England refers to sections 350 to 355 and 440, as well as some more specific provisions for dealing with particular errors. For example, section 266, which deals with applications that are not properly made, or 304, where there has not been compliance with procedural requirements within the appropriate notification period, or 357 to 359, where application has not been referred to the referral agency. Just over the page at 160, changing an application. An applicant may wish to change an application. A minor change usually doesn't create any difficulty, and a minor change is defined there as something which does not involve substantially changing the development, and that's section 350. That would, for example, include, and there's a list of them there on page 161, a new use with different or additional impacts or results in the application applying to a new parcel of land. So they would fairly logically be regarded as something other than a minor change. Page 161, there is provision for extending the timeframes and reviving lapsed applications. The Act allows for missed timeframes in 3 ways. You can apply for an extension, the lapsed application can be revived, or it could be a deemed approval in some circumstances. So it is interesting to see that an applicant has an ability in some circumstances to extend the timeframes in the Act to allow the applicant 5 business days from the date of the application lapsing to give written notice that the applicant wishes to revive the application. If you refer to table 5.1 on page 163, there is, I think, an excellent summary of the relevant IDAS actions, the relevant sections of the Sustainable Planning Act, the standard timeframes, the extensions possible without consent of an applicant, and extensions possible by agreement, and those which are possibly revived upon lapse. So that's a handy table to have handy. Deemed approvals, this is referred to on page 162, where England says, in addition to offering extensions and revival opportunities, the Sustainable Planning Act ensures some type of code-accessible development applications will be deemed approved if an assessment manager fails to make a decision within the appropriate timeframe. Now, just a couple of things there. Note that this deemed approval only applies in relation to some type of development applications, and more specifically, some type of code-accessible development applications. Code-accessible applications will be deemed approved under section 331 if the assessment manager does not decide within the period of time and the applicant, before the application is decided, gives a written deemed approval notice to the assessment manager. So it won't happen automatically. If the assessment manager doesn't provide a decision within the time frame, this code accessible application will not necessarily be a deemed approval. It will only become a deemed approval if, before the decision is made, the applicant has given a written deemed approval notice to the assessment manager. So one wonders, therefore, if you're working in this industry, why you would not always, simply as a matter of course, lodge a deemed approval notice with the assessment manager in relation to code accessible applications in all instances. At page 162, it does become more interesting because we now talk about, or England talks about, the Planning and Environment Court's power to excuse non-compliance. Reference is made to section 440 of the Sustainable Planning Act, and that provides the Planning and Environment Court with very broad powers to excuse or not excuse any non-compliance with the Act. Section 440 subsection 1 says, if the court finds a provision of this Act or any other Act has not been complied with or fully complied with, then subsection 2 applies. And subsection 2 says, the court may deal with the matter in the way that the court considers appropriate. And you can imagine that lawyers love that type of provision because it gives us plenty of room to argue. Now, I'm going to skip across to page 164, where England concludes that generally, the Planning and Environment Court uses the power quite generously to forgive any procedural mistakes that are made during the information and referral stage. This is the first 2 stages that we talked about in IDAS, but has shown more reluctance to excuse mistakes which are made in the application or notification stage. Sorry, I'll amend what I've just said and just go through that again. As you'll recall, IDAS has 5 stages. Number 1 is application, 2 is information and referral, number 3 is notification. So let me revise what I just said. The court uses the power generously if the mistakes are made during the second stage, information and referral, but not so much if made in the first, that is the application stage, or the third, the notification stage. At page 164, England refers to the case of Advanced Property Planners, Pty Ltd v Brisbane City Council, 2004, Queensland Environment Planning case law at 47. I'll just mention something here, and if I haven't done this before. When you're when you're referring to a case, two things. Firstly, when it's written, you'll see that it's in italics, is the way it would normally be written. Not the whole case, but just the names of the parties. And where it says V, don't use the word versus. It'll show you as being a novice in the area. What we do say is V, or sometimes and, or sometimes against. So an appropriate way to describe that case would be Advanced Property Planners, Pty Ltd against Brisbane City Council, or v Brisbane City Council, or and Brisbane City Council, but don't use the word versus. Anyway, now back to the case itself. In that case, the applicant failed to reply to an information request within the time given, and Judge Wilson, as he was then, made some observations. And Judge Wilson, as he was then, observed, so long as there is no question that the non-compliance has not substantially restricted the opportunity for an individual to exercise rights conferred by the Act, the object of the section is to avoid wasting time and assets in respect of technical difficulties with no substantial consequences. That was at paragraph 16 of the case. And once again, lawyers love that type of statement. Also at page 164, England concludes that it is inconsistent with basic administrative law principles and likely to remain an important consideration. It is consistent with basic administrative law principles and likely to remain an important consideration in the reasoning of the court. Justice Wilson, as he is now, was later appointed to the Supreme Court, and he took on the role of President of the Queensland Civil and Administrative Tribunal. And as you would have seen in the material, I'm a member of QCAT, so for some years Justice Wilson was my president at that jurisdiction. Just in terms of the way we describe judges, the general rule is, well, the rule is where we're talking about a district court judge, and a planning and environment court judge is a district court judge or district court judge level, we will refer to his or her honour as judge in that jurisdiction. When we're talking about a Supreme Court judge, we refer to his or her honour as justice. So Judge Smith means a district court judge. Justice Smith means a Supreme Court judge. In a social context, we would refer to either a Supreme or a District Court judge as simply judge. Anyway, that's an aside. Now, we go back to what England has to say, and the author contrasts the decision in Advanced Property Planners with the court's approach in other circumstances, where it states that if an application was not made properly in the first place, it was in effect not an application at all, and therefore could not benefit from the court's discretion to excuse any non-compliance with a requirement of the Act. And there's some cases referred to there: Lamb against the Brisbane City Council, Metro Star and Gold Coast City Council, and Chang v Laidley Shire Council. And the citations are in England at page 164. In a law course, you'd be expected to read these cases, and you're most welcome to read the cases. If you do, go through Ostley all through the authorised court reports and have a look. You can look at the head note, which is the summary at the start of the case, or you can go on and read the whole case if you wish. But for the purposes of what we're doing, my suggestion is that you confine your reading to the book, understand what's in the book, and I think that'll be fine. All right, anyway, so the principle here is that when we're talking about a properly made application where there is a non-compliance, if we adopt the wording of Judge Wilson as he was in advanced property, so long as there's not going to be a substantial restriction on individuals to exercise certain rights, the object of the Act is to get on with it and to essentially disregard technical difficulties. That approach, however, is contrasted to a situation where the application was not properly made in the first instance, in which case the section can't overcome any subsequent problems down the track. So these sorts of discrepancies between cases is what makes law particularly interesting and frustrating at the same time. The decisions that we've referred to were made under the Integrated Planning Act, and you'll recall that was the predecessor of the Sustainable Planning Act. In the Integrated Planning Act, where the word requirement was used, that has now been changed so that we talk about a provision rather than a requirement in the Sustainable Planning Act. This is likely to be regarded by the courts as a softer requirement as far as applicants are concerned, provision being a softer word than requirement. So that may mean that there will be a greater allowance or likelihood that the courts will excuse technical errors along the lines of the thinking of Judge Wilson. Now at page 164, England refers to the explanatory notes of the legislation, this is for the SPA, stating that a person's right to a hearing should not be compromised on the basis of technicalities concerning process. The term is intended to be interpreted broadly and not limited to circumstances where a positive obligation to take on a certain action. And once again, lawyers love the broad nature of the explanatory note as described. That discretion to forgive technical errors is under section 440 of the Act, and it's conferred upon judges of the Planning and Environment Court. There is no such extensive discretion vested in assessment managers. At page 165, England comments that an exercise of a discretion vested in assessment managers under section 304, which deals with power to assess an application despite non-compliance, does not preempt the discretionary exercise of the excusatory power of the court under section 440. Now the example case that she's given is very good. In Ramsgrove against Beaudesert Shire Council, 2005, an application to have the council consider a material change of use was submitted. The sign was in the wrong position. This fact was brought to the attention of council by submitters who opposed the development, and when senior officers recommended council exercise its discretion to excuse the non-compliance, that is section 304, the council approved the development by accepting that recommendation to excuse the non-compliance. In that case, Robin, District Court Judge, or Judge Robin, found that the council's decision was unreasonable, and in contrast to the council, he declined to exercise to use the excusatory power vested in the court. And that decision of Judge Robin was later confirmed in the Court of Appeal, and that's Ramsgrove against Beaudesert Shire Council, 2005 QCA, Queensland Court of Appeal 434. And the Court of Appeal found that a decision made by a council does not preempt the exercise of a similar discretion by a court under Section 440. All right. How are you doing there, David? You hanging in?
Yes, thank you. Yep,
Okay,
good,
thank you. All right. And for those of you who are watching on video through Zoom, please hang in there. But I'm hoping that it does help if we go through the papers, if we go through the book together, because I appreciate it is difficult. All right. England, pages 166 to 168, which deals with ministerial powers, specifically the ministerial call-in power. Okay, the minister has power to issue directions to assessment managers, requiring them, amongst other things, to supply the minister with a copy of all future applications for developments in a particular area, that's a geographical area, or postpone making a decision on an application involving a state interest. So what we have here is the minister, not in its legislative function, but the minister in its executive function, intervening in certain stipulated scenarios. In addition to that, the minister may issue directions requiring an assessment manager to attach particular conditions to an approval. So it's not saying that the development is stopped, but the ministerial direction is that certain conditions must be imposed. This can only occur in limited circumstances, however, and that is where a concurrence agency does not have jurisdiction. So if there's a concurrence agency with jurisdiction, the minister can't come in and impose conditions on the development. But if the minister does, there are strict requirements imposed in relation to his or her obligations in that regard, including the requirement to table such action within 14 days after the decision is made. So while it appears at first glance that the minister has considerable power to intervene, when one sees that the action can only be implemented when there is no relevant concurrence agency having jurisdiction, and there are strict requirements for accountability imposed, it is not therefore an action that would be taken lightly by a minister. The minister has power to call in and decide or redecide an application that involves a state interest. Now this is on page 167. The explanatory guide to the Integrated Planning Act justified the call-in power as one that ensures a comprehensive planning framework. Now that is a big ask. In Landell against Hinchcliffe, which is 2009 Supreme Court, at 408, the minister was advised not to call in an application for approval for retail showrooms in Mackay, and this is on 168. The minister did exercise that power anyway, despite the advice not to do it. The applicant sought a judicial review of the minister's decision. The Integrated Planning Act, which is now the Sustainable Planning Act, included no explicit requirement to inform the applicant of the minister's decision to call in the decision. However, Justice Freiberg in the Supreme Court held that any exclusion of common law rights to procedural fairness must be stated by plain words of necessary intendment, even with respect to inherently discretionary powers. Because the minister had failed to get the applicants or give the applicants any notice that the call-in power was being used or considered before the decision was made, the ministerial call-in was ruled invalid. So one can only imagine how displeased His Honour's decision was met when it was brought to the minister's attention. I'll move on now to pages 170 through to 186. And this is under the heading of Judicial Contributions to Development Applications. Applicants advice referral agencies and submitters are entitled to appeal decisions made on development applications. That I would have thought is pretty obvious. What's not so obvious is that the jurisdiction of the Planning and Environment Court in these cases is what we call de novo. What that means is that the court is entitled to look afresh at all the evidence and make its own decision on the merits of the case, but do so in accordance with the applicable law, and that's section 495 of the Sustainable Planning Act. I mentioned before QCAT. In our review section, we do adopt the same principle in relation to reviewing administrative decisions that are made in our area, and we do so by considering de novo. Now, we call that really a merits appeal. In determining merits appeals, the court places great emphasis on compliance with applicable planning instruments, and any deviation from applicable planning instruments must be justified on sufficient grounds. Okay, let's talk about the general method of interpretation. Decisions of the Planning and Environment Court have emphasised the following principles. Although planning instruments have force of law, they are not drawn with the precision of an Act of Parliament. Therefore, planning instruments should be broadly construed. They should be considered as a whole and with a sensible, practical approach. Don't you love those words? So, if we're looking at a planning instrument, we don't read it as if it's an Act of Parliament. We don't read it with that same precision in mind. We look at the whole of the instrument broadly and we interpret it sensibly and practically. In other words, not pedantically, not looking at one word only in isolation, but looking at the planning instrument in a very broad manner. Now, where there's an ambiguity or internal conflict, an interpretation which best achieves the overall purpose and objective of the instrument should be preferred. Now, I'm going to refer you to the comments made by Judge Wilson in Luke against Maroochy Shire Council and Watpac Developments. This was 2003 QPEC 05, where His Honour approached the question on a balanced but not unduly pedantic basis. At paragraph 19, His Honour said, "A planning scheme must be interpreted in a way which best achieves its apparent purpose. The court should take a common sense approach, and the particular document should not be read too narrowly, but rather broadly, rather than pedantically." Now, isn't that beautifully described? And isn't that a comfort for assessment managers and indeed applicants who, faced with a development which is not strictly in accordance with the terms of the instrument, can rely upon the words of His Honour in looking at the broader picture, the bigger picture, to justify the application and or the approval. The next heading is interpretation of state planning policies and strategic plan, page 172 of England. A similar approach, once again, taken by Judge Wilson in Stahira and Redland Shire Council, where the common sense approach was adopted. And it was found that even though the planning intent in question provided for some limited residential component, the development in question, as proposed, did create a detrimental impact on habitat values in clear conflict with the requirements of the policy, and accordingly the application was rejected. That was a case involving an application in relation to land at Wellington Point in the Redland Shire Council. In that particular area of the world, which is where I used to live at one stage, there is a great emphasis on conservation of koala habitats, and the strategic intent of the planning policy in question was to provide for conservation. In that instance, the application was for a small subdivision, as I recall, and it was ultimately rejected on the basis that even though there was some wording that said some limited residential component would be allowed, the overall approach of the policy was overwhelmingly in favour of conservation, and that's the way in which the case was decided, once again on a very practical basis. So that is the way in which cases generally can be considered. Now I'm going to give you a bit of break from listening to my droning voice and leave you to read the rest of that material, and simply go now to the conclusion on page 186 of England. The conclusion to the chapter, that is. So, notwithstanding the difficulties in initial implementation, England concludes as follows in relation to IDAS. In the meantime, systematic departmental guidance, ongoing training for stakeholders, standardisation of forms, increasing use of electronic processes, and a period of relative stability now offer the best hope for entrenching IDAS as best practice model for development assessment. And again, it seems extraordinary that as sophisticated we are in society, we're still, in terms of environmental law, seeing how new it is, how these things are just taking hold, and it's only now that authors such as England are able to conclude that IDAS is an appropriate best practice guideline into the future. All right, well that then brings what I wish to say for week 3 to an end. Is there anything, David, that you'd like to add?
No, that's all. That's good. Thank you, John.
Okay, thank you. All right. Well, I might stop recording, and all the best. Please do your reading for next week, and hopefully you can join us. Thank you.
Thank you.